Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of consumer law, especially matters involving that flat owners who are often forced by the circumstances to take possession of apartments even if the amenities promised by the builder are not provided, do not forfeit their right to claim such services from the builder. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled DEBASHIS SINHA and others versus R.N.R enterprise represented by its proprietor, chairman, KOLKATA and others, pronounced on 9th Feb 2023, the complainants invoked jurisdiction of National Consumer Redressal Disputes Commission after being aggrieved by the failure of the developers to provide services as promised, with allegations that despite paying full consideration amount and execution and registration of deeds of conveyance in their favor, the developers failed to provide them the completion certificate and also the common amenities. In spite of finding that the developers showed a very casual approach and were guilty of unfair trade practice, the NCRDC held that the complainants were not able to establish their claim and no deficiency could be attributed to the developers. Being aggrieved, the present appeal has been filed. The Supreme Court has held that the impugned order shows that the conduct of the developers was far too casual, and on the face of it, the developers are guilty of unfair trade practice within the meaning of Section 2(1)(r) of the Consumer Protection Act. But NCRDC went on to hold that this does little to rescue the complainants. If complaints were to be spurned on the specious ground that the consumers knew what they were purchasing, the object and purpose of the enactment would be defeated. Any deficiency detected post-purchase opens up an avenue for the aggrieved consumer to seek relief before the consumer forum. The reasoning of the NCDRC is thus indefensible. NCDRC might have missed to appreciate the present-day realities of life. The usual delays that are associated with construction activities result in undue anxiety, stress, and harassment for which many a prospective flat owner, even without the project of flat being wholly complete, is left with no other option but to take possession. Whether upon taking possession a flat owner forfeits his or her right to claim such services which were promised but are not provided, resulting in deficiency in services, is a question that NCDRC ought to have adverted to. Once NCRDC arrived at a finding that the developers were casual in their approach and even resorted to unfair trade practice, it was its obligation to consider complainants' grievance objectively and upon application of mind and thereafter give its reasoned decision. If at all the complainants did not forfeit any right by registration of sale deeds, and if indeed the developers were remiss in providing any of the amenities as promised in the brochure, it was the duty of NCDRC to set things right. The complainants had genuine reasons to feel aggrieved, and the same was clearly documented in the report of the valuer, which was even acknowledged by the NCDRC. Yet a peculiar approach was adopted, and the developers absolved their obligations by an order which appears to be unjustified. The impugned order speaks of certain facilities to be made available by the developers on payment of extra money. However, there is no such clear-cut description of amenities which the developers asserted would be provided on payment of extra money by the complainants. NCDRC would have done well to indicate the same with clarity. The approach of NCDRC was perfectionary while dealing with the complainants' contention that it was the duty of developers to apply for and obtain the completion certificate from the Kolkata Municipal Corporation, and that the developers ought to have been directed to act in accordance with law. The observation made by NCDRC of the developers having successfully argued that it was not their fault and that no completion certificate of the project could be obtained is clearly contrary to the statutory provisions. It is evident from sections 403, 390 and 394 of the Kolkata Municipal Corporation Act that it is the obligation of the person intending to erect a building or to execute works to apply for completion certificate in terms of the rules framed thereunder. It is no part of the flat owner's duty to apply for a completion certificate. When the developers applied for permission to erect, the Kolkata Municipal Corporation Building Rules 1990 were in force. Rule 26 happens to be the relevant rule. In terms of sub-rules 1, 2, 3 of Rule 26 thereof, the obligation was required to be discharged by the developers. Evidently, the developers observed the statutory provisions in the breach. NCDRC referred to section 403(2) of the Kolkata Municipal Corporation Act only to permit the developers to wriggle out of such obligation and arrive at a completely erroneous finding that no deficiency in service could be attributed to the developers, since both the developers and the complainants acted in violation of law. True it is, the complainants ought not to have taken possession without the completion certificate. However, that was not a valid ground not to direct the developers to apply for and obtain the completion certificate as required by law. The mere fact that the flat owners were being assessed by the Kolkata Municipal Corporation affords no reason to the developers for breaching section 403(1) of the Kolkata Municipal Corporation Act, read with Rule 26. Of course, once a completion certificate is issued by the Kolkata Municipal Corporation upon conducting appropriate inspection and test of the building that has since been erected, it would stand to reason that the same amounts to a certification that the building does not suffer from any violation of the building plan sanctioned for the purpose under section 390 of the Kolkata Municipal Corporation Act, or that its constructional quality is not of the desired level for which it is unsafe for human habitation. The developers were let off by NCDRC in a manner contrary to law. This is an appropriate case where the complaint of the complainants ought to be remitted to NCDRC for taking a re-look into the complaint in accordance with law. The remand is directed only with a view to secure adherence to the promises that the developers made in the brochure and or advertisement, as the case may be, and thereby cover up deficiency in service, if any, as well as the mandatory statutory provisions.